This podcast is watched by people all over Southern Africa, even as far as the UK. So people are asking themselves, can a foreigner acquire land in Botswana? What's the answer?
They only came to us at that stage when now they wanted us to go to court. So that already now by themselves found out that, wait, I gave money and then I found out they're not even the owners of that. So obviously it doesn't matter whether you're submitting it at the deeds office or the land board, they will not transfer that property.
You should also check, if you are instructing an appraiser to do valuation for you, you should also do your due diligence and check if that person is registered legally, because so you find that some fly by nights will give you just wrong values of your property, either undervalued or way overvalued. And
back in the day, a person could not go with a certificate to a bank and say, can I please have a loan? I'm using the certificate as security. Back in the day, you could not do so, and there was a large outcry from the people of Botswana.
This is Mogobe Nuggets of Wisdom podcast. We enthuse, we energize, we inspire, and we empower entrepreneurs and entrepreneurs of all stripes in BW and beyond. Hello, Dumela, and welcome to another episode of the Legal Series, a part of Mogobe Nuggets of Wisdom podcast. Very, very excited to welcome you once again. I have a reconstituted panel which is here to discuss issues relating to conveyancing, more particularly sale agreements relating to immovable property. I've got a conveyancer and an attorney, and I also have a member of our team at Mogobe Incorporated. We're going to delve into these issues to help you dissect them and understand them better. And as always, let me ask you to strike that notification bell and that subscribe button. We need that support from you. That's all we ask. And of course, a shameless plug, we have The Nuggets of Grit, my book, from the cattle post to serial entrepreneurship. It's available here at Mogobe Plaza on the first floor. All you need to do is to reach out to us on 397-1368, and the book retails for only 360 Pula. It's also available at the Airport Junction office or store of exclusive books, so you can get it there. And as always, I have a great panel for you, and they will introduce themselves briefly. But once again, don't forget to hit that subscribe button. Let me start on the far left. Tell them who you are and what it is you're going to, what you bring to the table in terms of your background.
Good day, viewer. Good day, listener. My name is Pheto. I'm a operations manager here at Mogobe Incorporated. I'm also a realtor with 14 years experience. Today we're going to discuss the sale of immovable property and all the nitty-gritties of how to get to do sales agreement and what is needed out of that agreement.
Okay.
Thank you.
Over to you, madam.
Good day, everyone. My name is Thokozile Nyirenda. I'm the managing partner at Lerumo Mogobe Legal Practitioners, and we believe that we're going to feed you exactly what you need to know when it comes to sale of immovable property in Botswana. Thank you.
Okay.
Good afternoon, viewers. My name is Kudakwashe Chihita. I'm an attorney at Lerumo Mogobe Legal Practitioners. For over 2 years, I've been with the firm. I'm also a master's candidate with the University of Botswana. It's a pleasure being here. Thank you, Mr.
All right. You're just going to love this one, guys. I forgot to mention that we are powered by Lerumo Mogobe Legal Practitioners. These the people who are on my left who are the ones sponsoring this. They've even afforded us some water. But let's get the ball rolling. What is immovable property, Mr. Kuda?
Immovable property, that is a property that cannot be moved. It's as simple as that, as the name says. But in terms of layman's language, immovable property is generally land. Anything that is land related is immovable property. So be it a bad piece of land or a house on a land or a commercial building on a land, that is all referred to as
My language, you're really referring to a piece of real estate.
well, yes. In your language as a real estate person, then yes, it's a piece of real estate, but in a legal terminology we call that immovable property.
Okay. Nyirenda, I understand that the immovable property confers real rights. Could
Yes.
you help the viewer understand what that means? How do you describe these real rights?
Okay. Real right is an absolute right. It basically is what deals with the relationship between the holder of the right and the thing. It gives the grantor, and that's the person who's the holder of the right, power over the thing. It gives them complete power, and it also cannot be challenged. So I won't get into other types of rights, but when you're dealing with land, and an example of a real right is you being the owner of a piece of land on a title deed. You are the named owner of it. Therefore, when I mean by it can't be challenged, you see, there is no dispute about it. The title deed says that you are the owner, and that's that. So that is an example of what a real right is. Yes.
Okay. Mr. Pheto, you interact with immovable property on a day-to-day basis. Can immovable property be sold? And to the extent that you have been exposed to those sort of transactions, can you share with the viewer a little bit more, giving one or two instances?
Yes, immovable property can be sold from one entity to another, and normally when it's sold, it depends whether whoever is buying, is it buying through a bank or just buying cash. But the most important thing that is done is what we call the sale agreement, which is have some different clauses and terms and conditions that are agreed by both parties or both entities who are involved in a transaction. So basically that is it, and that property should be, one should have that real right over it.
Okay.
You can't just sell immovable property that is not yours. so you have to have the real right over
Okay.
it. Yeah.
And it's not just any attorney that can be involved in dealing with and transferring immovable property. I understand it's people called conveyancers only who do that. Tell us what a conveyancer is, and you are a conveyancer yourself, Nyirenda, and what it took for you to become one.
Okay. A conveyancer is an attorney who deals, specifically conveyancing is dealing with property. So they are the ones who sign all the documents that are needed to facilitate the transfer. Specifically because there will be a buyer and a seller who signs the documents, but there are actually specific parts that need to be signed by an attorney who's a conveyancer. And as you said, not every attorney is a conveyancer, so you do have to be an admitted attorney for specifically conveyancing. And what that requires is that when you become an attorney, you're admitted as an attorney, and that is a separate application that you do at court. When you become a conveyancer as well, you are also admitted at court, and it's separate. It's not actually done at the same time when you become an attorney. The first step is to become an attorney, then you apply for admission as a conveyancer so that you have a practicing certificate as a conveyancer in Botswana. And it's something that is renewed annually, but you only are admitted once.
Okay. Is there any kind of specialized training that a conveyancer needs?
Well, it depends. I'd have to go. It depends on the background of your studies. If you studied in Botswana, there's already at UB. There's already courses. I'm just using UB as an example. There's already courses, part of the LLB, that is conveyancing. So that you've already done it, and therefore you can just apply because you've already done it in your degree. Now, if you studied outside of Botswana, what is required is that, irrespective of where in the world you studied, but as long as it is not Botswana, you're going to have to write bar exams. And one of the bar exams you're going to have to write if you want to be a conveyancer. You don't need to do this exam if you never have intentions of wanting to be a conveyancer. It's called the conveyancing exam. So once you've passed that, you're going to actually include that in your application at court to be a conveyancer.
Botswana's system of law recognizes different types of law, freehold, leasehold, agricultural land, tribal land. Would you care to just help us with the definitions and as well as highlighting the distinctions between these?
Okay. In Botswana, the three main lands which are dealt with is freehold, is tribal land, and is state land. And then as well, it's not one of the three, but then there's also dealings with agricultural land. So I'll start with state land. State land is exactly what that is. It's owned by the state, owned by the government. Tribal land is land that is in a tribal area. So as you know, Botswana, we all know that there are tribal areas. So each area, yes, that's what tribal land is. And it's managed by the land board, basically. Yes, those are the administrators. And then there is freehold land. Freehold land is what is when you have ownership of the land that is perpetual. So in layman's language, that means that you can own that property forever. Unlike, for instances, when you're dealing with, let's say, other types of land, there could be a lease. And you would have to renew that lease. So it doesn't mean that it will be in your name and you own it forever. That is what freehold land is. And agricultural land, I'll just say it's self-explanatory. That's farming land. And that also has a certain, depending on who's buying it, there's a specific way the law goes about in dealing with that, depending on who is buying that type of land.
Okay. Mr. Gape, what sort of agreements do you normally deal with when talking about immovable property? I know there's a document called the deed of sale. Can you tell us a little bit about it and what role it plays in the entire transaction as you transfer that land from the seller to the buyer?
Deed of sale, it's more like a contract where whatever the entities are involved in that transaction, it outlines quite a number of clauses or I'll say terms and conditions. More especially, you have to have more like the whatever that is being sold or the property that is being sold should be highlighted there. Should also have the breaching or the breach clauses. It should also indicate the sale price. It also indicates the indemnity clauses and all the like.
Okay.
Yeah.
Do you want to add on to that, Nyirenda? What are the essential components that you insist on including in that deed of sale?
Well, just to add on what he said, it is very important to have a clear description of the property. As I said, the purchase price, you have to also state how it's also going to be paid for, because usually there's a deposit that's paid. So it has to be very clear on how that will be paid and then what's the full amount. It also has clauses such as breach, cancellation clauses. If you want to change the terms, it has to be agreed on between both the parties. Yes, those are just to say a few.
Yeah. And is it something that can only be done by a lawyer, this deed of sale, or how does it work?
Well, a sale agreement, it does not need to be done by lawyers. Parties actually can do a sale agreement. It's just that people prefer to do it with lawyers because they want to make sure that all the essential clauses are covered. So, but nonetheless, it can be done by just individuals or who the buyer and the purchaser are.
Yeah.
Yes.
Mr. Kuda, do you think it's important to use a lawyer for such a document, the sale of land?
Yes, it is. It's very important to use lawyers because, like has been said, many a times when laymen draft these documents for themselves, they forget to enshrine, or rather, they don't know which clauses should be inserted within such an agreement, and also by reason of them being a layman, they do not know the dangers that arise as a result of not enshrining some provisions within a deed of. So as such, it is very important that whenever anyone is making any transaction, any dealing with regards to land, it is important that they visit an attorney who will advise them and draft for them a proper, a standard, and up to par deed of sale.
Yeah.
The importance cannot be overstated because the loss can result in millions.
Indeed. When I talked...
Also,
Yes,
sorry.
you want to add?
Let me just add on that. I think just to add on the essential clauses, there's also a footstoot clause, and there's also...
Explain footstoots.
Okay, footstoot, yes. Footstoot.
Yes.
Yes, it's actually an Afrikaans word. Yes, what it means is that you are buying the property as it is. If the agreement has that, that means that irrespective of whatever defects are in the property, so you can't buy it and say that after you've signed
Both latent and
yes,
patent
latent
defects.
and patent. So those are
Defects,
the layman visible and the ones that you don't see defects. So you can't say later that wait, I see that no, the ceiling was falling off. I changed my mind. The moment that clause is in a sale agreement, that means that you've accepted whatever condition the property is in. Yes. And then another important clause is a dispute. So now when there's a dispute, this
Dispute resolution?
resolution, yes. So let's say there's an issue pertaining to anything in the agreement, and it will say whether there's arbitration. Court is not always depending on which agreements are done, how they're drafted. It can either go to arbitration, or it can say that it must go to a competent court to deal with it. So that's just a few more.
But I would obviously be biased towards the courts because of arbitration can drag and it can be very expensive.
It can. I actually do also agree that you're better off in whatever contract. It's not even just about the subject matter that we're dealing with today. We are better off to actually have a clause that states that you're going to go to court. Court is, you can also say that court can take long, but arbitration, when the parties are not agreeing, because you do have to agree to an arbitrator. And that is actually something that can drag. Someone will say, no, you're picking someone who they feel as if will be a bias, just as an example. So that process can take very long. And usually what happens in arbitration is that is it. So there usually isn't another option to say that if I don't agree with what the arbitrator says, then I can go to court. When you come to court, or appeal, exactly, that's where I was going to. When you come to court, let's say it's at a lower court, so it can either be magistrate's court or a high court. You can always appeal that decision to a higher court. So there's still a chance of the decision changing. So I feel as if that court is just a better option in that regard.
Okay, you're a realtor, Mr. Gape. Oral or verbal sale agreements for land, is there such a thing? And have you come across it?
Yes, but verbal. We can't accept verbal agreement in terms of sale of immovable property or land.
When you said yes, you scared me a little bit.
I said yes. I came across that, but it's not something that can be allowed, because obviously verbal agreement, like in the previous discussion, we know it's something that you can't enforce or maybe outline anything because it's just verbal. But sale agreement should be written. As far as I know, all transactions that I've dealt with as a realtor, I've dealt them through written agreements. I haven't really done anything verbal. So what is encouraged is what is written, and that can be enforced, and that can be can be tangible, be seen there and read by someone.
Is there, Nyirenda, a piece of legislation that guides us on this issue of whether or not agreements can be written or not? The Deeds Registry Act, doesn't it?
Yes, I believe the deeds should also mention it. It's also just what we call common law as well, that or purchases of land have to be written, and as I said, otherwise they'll be unenforceable. And that meaning, for those who don't understand what that means, unenforceable, that means that if there's an issue, because you can have a verbal agreement, and then you pay someone, let's say you're buying property for 50,000 pula, and then you pay them whatever amount, so let's say 50%. You can't now be saying, and you can't go to court and say we had this valid agreement, and you are trying to enforce it. So that's where you find that there's issues, because the agreement was basically illegal in the first place.
Yeah.
Yes.
When I talk to my mentees, what I teach them is that you can initially have an offer letter. Can you help the viewer understand what the distinctions are? The offer letter before it becomes a deed of sale. Is it a binding? Do they have the same level of force? Can you just take us through that, Mr. Gape, and then Nyirenda?
Yeah, offer letter, it's more like the preliminary stage of, trying to acquire whatever the immovable property you're acquiring. It's more like showing interest in it, and then it doesn't really cover a lot of clauses or, legal binding clauses. So it's just showing an interest. In that offer letters, yes, you can put it in a way that it's irrevocable. I don't know if I'm saying it right. And later on, after some they can put in after due diligence and bank finance, then we can have now the deed of sale, or what now we call the sale agreement. It's more like a first step of showing
maybe
interest.
to hold the property.
Yes,
to help
more
you
like
hold
that,
it.
Yeah, but it doesn't have a lot of content as like the deed of sale. So we encourage after that, now you do the deed of sale.
Do they
cover
all carry the same legal weight as the deed of sale, Nyirenda? The offer letters?
No, they don't.
No, not really.
An offer letter is not legally binding, really. It what it does, it's for certain purposes. So, for example, let's say the buyer wants to get a loan to purchase the property. So when you actually go to the specific bank, they will actually want an offer letter. So it's just so that they can do the breakdown and then obviously show you what amount of loan they'll be able to give you. So really, it's just like it's what it shows is that I'm interested in purchasing that property, but it is not actually the agreement that you've entered into to purchase that property. So you can back out. You can back out, and usually it can help both sides. It can even have a section which says that it'll only be valid for 1 month. So maybe 1 month to go give the buyer time to sort out bank-related issues, and after that, then they can even offer it. So they can keep that property, saying that okay, we'll keep it for you for 1 month, and after that, if there's no signed sale agreement, then that's it.
Yeah, what I teach is that you can do one which is subject to due diligence and bank finance for purpose of holding the property and committing the parties to the deal.
Yes.
But of course, if the due diligence doesn't come through and the bank finance doesn't come through, the deal will automatically collapse.
Yes.
But of course, for you now to transfer, you need an actual deed of sale. Yeah. Now, have you come across instances where the parties chose to do the deal themselves, and what consequences, if any, give, just to illustrate to people that, because the example I normally give is that when you go to a doctor and you need an operation, you don't just go into your kitchen and start cutting yourself up to save money, you go and have the operation done professionally. So the same thing with certain legal things. Get a professional to do it. But that having been said, what I'm asking is, Can you give instances, examples, to share some of the experiences you've had in this area where people have not properly attended to the legal route?
All right. We've had quite a number of cases wherein people walk into the office and they tell us that they're having a problem with the seller of the piece of land or with the buyer. And many a times we then ask for the agreement of sale to say, can we have a look at the agreement of sale, because it dictates the terms and conditions, it has the dispute resolution clause as has been said earlier on. So many a times when you then look at the agreement of sale that is taken out by a client, it's almost close to a laughable piece of paper. It's like they just tear a page from an A4 book and then they simply write to say, I, John, I'm selling this piece of land to Michelle for 10,000 pula. Then they sign. That is it. But then
some go to the police and have a police stamp and think it's enough.
Yes, but then the question is, you have left out a lot of essential elements. You have left out the Voetstoots clause, that hasn't been mentioned. You have left out the breach clause, that hasn't been mentioned. You have not talked about payment of deposit. How will payment be done? Who will handle the transfer costs? So many a times clients then come to us and say, Ghana, I bought this house, but it has got this defect. But then within that A4 paper that they drafted, their agreement of sale, it says nothing about latent and patent defects. Or many a times, I remember early this year, I dealt with a case wherein the seller was saying, I'm not going to release the certificate until I've been paid all the money. And the buyer was saying, I can't give you all the money before transfer gets into my name. But they had already drafted their own agreement of sale on a piece of paper.
Which didn't cover that aspect.
Which did not cover that aspect. So I then had to sit down with the two clients and I said, you know what? If the two of you stick to those positions, you won't go anywhere. You won't. Therefore, I then had to propose to the client to say, okay, fine. Can we as the lawyers have the certificate, and then the client, the buyer, he pays money into our trust account. We as the lawyers will then facilitate the transfer, and then one transfer has been put into the buyer's name. Then from our trust account, because we are already having the money, we'll give it to the seller. But had it been that those people, right from the instance, they got into contact
so
with
you were able to save the day in that example.
Yes, we were able to save the day at a higher cost, of course.
Yeah.
But had they come right at the instance and said, can you draft an agreement of sale for us? Each and every party could have gone home knowing clearly what their rights and obligations are in terms of that deed of sale and in relation to that specific deal.
Wow. That's very interesting. Nyirenda, any horror stories to share?
Yes. I think this one is one of the worst ones. You don't want to catch yourself in this scenario. So we dealt with a case once where someone had purchased land and later, when they were dealing with the whole transfer, they found out that the seller was not actually the owner of that land. This matter even had to go to court. So now you see, in that type of case, and
was he a fraudster?
Yes,
he a fraudster?
Exactly. It was even a relative of theirs' property. So, they were they knew what they were doing. So now that was the main issue. So you have to ask, they only came to us at that stage when now they wanted us to go to court. So that already now by themselves found out that, wait, I gave money and then I found out they're not even the owners of that. So obviously it doesn't matter whether you're submitting it at the deeds office or the land board, they will not transfer that property. Because as we spoke earlier, the real right owner was not the one who sold that land. So now they have this headache, they have to engage attorneys, they have to go to court to claim their money back. And you ask yourself this, when you go to an attorney, and okay, this is an attorney who really should do their job properly. So I have to emphasize that because maybe some attorneys will skip this part. But you have to ensure that usually lawyers will ask you for the copy of the certificate. So this is part of what we call due diligence. So we look at the copies of the certificate. There are more other things you do, because actually it's also happened that people can have fake certificates. So on top of that, you have to go to, for example, the land board and actually confirm with them, is this a valid certificate, and can they confirm the contents thereof? So that was a horror story, but at least the good thing is that the judge agreed in their favor, so they did win the case. Yes.
And they got their money back,
Give
hopefully.
consent.
Yes, they did.
Yeah.
They did.
All right. So, in terms of just the whole process, there have been instances where there's been a failure, especially with the change of the law, where there's been delays and there's been a failure to get transfer. How have you been maneuvering through that change of the law? Perhaps you can even share on that. Around 2022, there was a new Tribal Land Act, Amendment Act, and then there were things called SLTs, Certificate of Secure Land Title. Yeah.
Secure land title.
Can you just share with the viewer a little bit of that and how you as conveyancers are dealing with that change?
Okay. The main issue is that, whether you submit a transfer at the land board or the deeds office, there's a certain period of time it's supposed to take. So at the end of the day, I'll speak about the deeds office, depending on how busy they are. So I wouldn't say, because the change of the law happened a couple of years ago, so the institutions have adjusted to the processes. It was a bit slower when it just started, but I would say that the issue is not really so much of the change of the law right now. The issue is now that these transfers are still taking long at these offices, but it's not actually because of the change in law. So various factors, such as it could be a busier period, they have more transfers and the documents are being delayed because of that fact, or sometimes there could be issues, and then maybe depending on the communication, they can take long to let the attorneys know to amend their papers. At the land board, I would say, when it comes to now the land board, it really just depends on which land board. I just have to say this because it's just
It's
a
true.
fact. But I would say that, like, the Mogoditsani Kweneng land
That one
board,
is a nightmare.
that one, it takes forever. And it's just known that it takes long for whatever the various reasons could be. So, but if you had to submit to other land boards, it would be
It's okay.
Yes, it would be much quicker.
Yeah.
I think for Kweneng, it's because there were a lot of issues regarding fraudulent acquiring of land, making fake certificates. I remember I had a similar situation whereby my land in Gaban, I had to take the longest time for it to be changed from my parents' name to my name, saying it was not legally allocated. I had to go to land tribunal to argue there. There was a lot of issues.
But you managed to win.
No, I managed to win because now they couldn't, really give the land tribunal the reasons why they can't allocate me or transfer the land to me. And I said, no, give him the land. It's his. Yes, it's a big land. They ask, why did you get such a huge land? No, I'm getting it from my parents. So give it to me.
Congratulations. Okay, so for those who might not know, how is this SLT different from the original leases and the process of transfer? What are the key distinctions between the old system and the new system?
Well, I think there is no much of a major difference, in the sense that both of them, at the end of the day, they give effect to real rights over a piece of property. However, back in the day, a person could not go with a certificate to a bank and say, can I please have a loan? I'm using the certificate as security. Back in the day, you could not do so. And there was a large outcry from the people of Botswana. But then with the coming in of the secure land title, it comes in as a panacea or as a cure to that defect that existed before.
You mean you can register a bond over that piece of paper?
So now with the secure land title, and now they now have to be registered with the
Deeds, yes.
So it's no longer just the landlord printing out as it
You
wants
also now need to
willy-nilly.
make it a-
No, it has to be done. It has to be stamped and signed by the Registry of Deeds. So that gives the certificate more weight and gives the property more weight. And above all, you can use it to your advantage by using it as security in financial institutions.
Now, let's talk about the purchase price. What advice do you give to the sellers relating to how it ought to be paid in terms of managing the money and managing the risk? In other words, should it all be paid at once? Should it be paid at the beginning? At what point should it be paid? Do you have some advice in that regard?
I think before we go there, we need to know how the purchase price is gotten to. You know, we need to be able to ascertain the purchase price before we can talk of paying it. And I believe that's his area of expertise, isn't it?
Yeah. You have to first acquire the appraiser, just to
Otherwise known as evaluation.
Yeah, known as evaluation, and so that you get the exact, open market value. Then you'll know what you are really paying for. Sometimes you find that I'm selling my property or my movable property at this much, whereas he was also doing it because he's got other financial problems that he want to also include in that price. So we don't want that. We're in a situation where it's open market value. You should have a professional valuer to value. It also guides everyone who's involved in the transaction.
But some people say valuers are expensive and they take too much time, and I want this money fast.
No, the appraisal itself, it doesn't take that long. I think most of them, the turnaround time is 48 hours.
Really?
Yeah. It doesn't take that much time. Yeah, but again, that appraiser should be. You should also check. If you are instructing an appraiser to do valuation for you, you should also do your due diligence and check if that person is registered, legally. Because so you find that some are fly-by-nights will give you just wrong, values of your property, either undervalued or way overvalued, and so you have to also do your due diligence if you are engaging, appraiser.
What is the role of? You want to add to that?
I now wanted to answer the question that you did.
Yes. Okay. Yeah.
Yes. But I think you add on because as lawyers we've got different strategies. So I usually tell clients that even if lawyers will have done due diligence, it's always advisable that a portion of the purchase price be paid as deposit, and then the remaining balance be paid after upon transfer, when transfer of the property has been effected. Because as a buyer, one of the things you wouldn't want is to pay 1.5 million pula, give it away to a seller, and then when you submit papers to the land board or to the Registry of Deeds office, then be informed, there's a caveat here, or maybe there are issues. It can frustrate you a lot. So at least if you have paid 50 or 60% as deposit, you have the 40 or 50%. So that is what I usually advise my clients, and it acts as a security means.
Yeah.
So usually I say pay 60 or 50, then the rest you can pay it when
still on that point, there's an added advantage to seeking a mortgage with a bank or applying for a loan, because the bank will not part with a single tab until the bond is registered and is in place.
Yes,
so I generally advise people that even if you have the money, if you can help it, get it funded through the bank. You can always make a plan to do whatever later with the money, but it helps. It's another reason, because some people are petrified of loans, so it helps for them to go through a banking institution. as well. But does Nyirenda want to add to that?
I think Kuda has explained it well.
Mm.
I think
I've learned that from her.
That's good.
The most important thing really is to manage your risk. Of course, I'll say this: the seller will be there saying, "Yeah, they want the full price." Of course, they have their own interest. But I'll speak for the buyers that you have to manage your risk. So there are so many issues. It's really one of these transfer of land. There's so many issues that have occurred, and really you have to be careful, because you imagine, even if you give 50% or 40%, you still now have to find a way to recover that, and you don't know even if actually that person still has that money. Most of the times they've already spent that money. So now imagine if you now gave 100%, and it makes them
God
also,
forbid.
yes, and it makes the seller as well do their part. You see, now when you've paid everything, what would make them,
What incentive do they have?
Incentive, exactly, because I've seen cases, and we've had these cases where they've been paid full price, and we are now representing the buyer, and could have to take them to court. And only now, when they find out maybe there's a lawyer involved, that's when, specifically what I mean is that they wouldn't even have submitted the papers at the land board. So you are thinking that you're still waiting for the process of transfer to take place, but in fact they actually haven't even done anything, and you've given them all your money. So yeah.
What is the role of a trust account in all of this? I suppose it's a two-part question. What is a trust account that a conveyancer has, and what's the role can it play in all of this?
Well, a trust account is a special type of account, and it's very few institutions that are able to actually even get these type of accounts, such as lawyers. What happens is that a trust, you're holding money for clients. That's the main part about a trust account. So therefore, and they're regulated, so you can't be doing anything that you want. We have to submit, just as lawyers, we have to submit annual audits on the accounts, and it's literally one of the most crucial parts about managing, or let's say having your own law firm. The trust account, you have to be very careful with it, because if the things are not in order by the time, and these reports have to be submitted at the Law Society annually. So if there's a bad report, it's as simple as you're going to have to close shop. You will not get a practicing certificate. That will be the end, you see, of you practicing as an attorney on that, based on that trust account report.
So what role does it play in the conveyancing?
In the conveyancing part, what happens is that I think my colleague here explained an earlier example where he was negotiating with the client, and it's about holding money. So some say that, the seller will say that, I understand that you can't give me all the money, as we're saying that you won't get 100% of the purchase price. So what the parties usually agree is that whatever portion that is outstanding from the deposit that was paid, it should be kept in the lawyer's account. And that way, the seller will have the assurance that that person actually does have the money to pay for that property, but then the buyer also gets the comfort that it's not going straight to the seller. It's being held basically by a lawyer, and it's supposed to be kept there for as long as the transfer process takes, until it's complete. Then the lawyer will give it to the seller. Or let's say something happens along the way, the agreement now has to be cancelled because maybe you found out things that they were not proper and the transfer can't continue. Then obviously that money will go back to the buyer.
Yeah. Also realtors are encouraged to have trust accounts, because in the constitution there is where realtors also are encouraged to have that.
But are they regulated? Are they
forced.
regulated to the same extent as the law society? Because with law society, with lawyers, there's a law society which sends auditors to audit, to check.
Yeah, if you're a realtor and you have that trust account, as they are encouraging it, you have to also tell them, the regulator, that you have that trust account. Then the process is the same as the lawyers. It also have to be audited and all that. So they are not, for now it's not forced, but it's encouraged for realtors also to have trust accounts, because we also deal with monies at one point, whereby we involve the seller and a buyer, and even you can some have even rentals or deposits for some other, because we also do management, property management. You can have good as rentals to go into the trust accounts and disperse from the trust accounts to the actual owner of the property.
Before we leave this trust account issue, what happens to the interest that accrues? To whom does it accrue? Or is it something that differs from one agreement to another?
It's kept to the holder of the trust account.
Yes.
Yeah.
Yes, that's it.
It's for the lawyer to enjoy.
You're not. If you
I
want
don't
an
know about
interest
enjoy.
Well, not enjoy, because at the end of the day, that interest you use it to pay auditors, most likely.
And to cover costs.
To cover other costs.
I
But
think
if it's a lot, then maybe you can, push it into the law firm.
no, the answer is no. You can't. And what? Yeah, because it helps defray the costs
Yes,
that.
yes.
I just wanted to ask Nyirenda, this trust account, the bank is it a certain amount that maybe the lowest amount you can have in the trust and the highest amount is just an open account, whether you can have 1 tebe in it or 100 billion in it, or there are some minimums?
There really isn't a minimum or a maximum,
Okay.
so it's just there's a certain way that they have to be managed.
Okay.
So now you see that there are many firms. Nonetheless, a law firm needs to. You can't operate a law firm without a trust account. Some you're just starting off, so maybe you're getting your 10,000 pull up a month, and some are making 1 million a month.
Okay.
Nonetheless, it's the same.
Okay.
Okay.
But
Okay.
just to add on, because of money laundering and banks' efforts to curb such, when you're holding a trust account and maybe you're expecting millions and millions of pullers from clients in
Yes.
Germany, high risk areas, you have to inform the bank to say, so and so is my client, I'm doing such and such and work for him, and within the next month, most likely we will receive 5 million puller from this client, because you wouldn't want a situation in which, as a lawyer, the bank is against you, fear is now on your back, DIS is now
Fear,
on
by the way, is
yes,
a
the Financial Intelligence Authority.
authority.
Yes, is now on your back asking you, my dear Jaka, and they can even go to the extent of freezing your account.
Yes.
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 It has been known to happen.
Yeah,
It happens
Yeah,
more
it
frequent
really
than
does.
not.
All right. Now we want to talk a little bit about the due diligence that is involved, apart from the lawyers checking with the land board. Can you think of any aspects of due diligence that the attorneys help with?
Yes, there's also checking at the deeds office.
Mm-hmm.
So literally that one, you have to write them a letter and inquire, is this, it's what they call a deed search.
Mm-hmm.
So there's a small fine, I think it's 50 pula you have to pay. And then you have to write a letter, because also you can't just be any person writing to them. They prefer that it actually comes from a lawyer. Saying
Who
that
is a
we're-
conveyancer?
Exactly. And then you write to them and they confirm whether that deed actually exists, and if the things that you want to look out for, and the purpose of such as a deed search is that someone can sell you land which, let's say, it went through a court case and it has been attached. So if I have to say what that means, it means that, let's say you were owing someone else money and they were able to successfully win a case at court and get judgment against you. So that means that they can even go send a deputy sheriff, they'll do a search at the deeds office, and whatever that's in your name, they can attach that at the deeds office. Now, and this happens very often in practice, that same person, knowing full well that situation, will still be trying to sell that property. So those are the purposes, because at the end of the day, you don't have more of a right to say that, no, but that person sold me the property. That if it's already attached first, then that's it. The whoever who has attached that property is now the
Has
one who's
greater
in,
rights.
exactly who has a greater right to that. So that is one of a very important aspect of that.
Of due diligence.
Yes.
Now, in terms of verifying things like the source of the money and making sure that the person who's buying is not a fraudster, the fiat stuff, do lawyers get involved that far?
Well, it depends. Because many a times as lawyers, our job is to advise client, and client is the one who then instructs us. So we can simply put it to the client that, you know what, we can investigate further, we can instruct or involve private investigators to further investigate on the seller or on the buyer.
If there are suspicious circumstances,
Yes, if there are suspicious circumstances, yes. So, but above and beyond, our due diligence cannot go beyond what we have been instructed, because we act on instructions as lawyers.
Yes. This podcast is watched by people all over Southern Africa, even as far as the UK. So people are asking themselves, can a foreigner acquire land in Botswana? What's the answer?
The answer is yes, they can acquire land in Botswana. It just depends on what is the type of land. So earlier we had discussed that there are different types of land in Botswana. There's freehold, there's state land, there's tribal land, and there's also, as I said, just a fourth one, agricultural land as well. So it depends what they are trying to acquire. The ones that they are allowed, permitted by law to acquire, is freehold. That one, they can acquire it without any issues, without any further legal processes, just a normal seller and buyer transfer process. But when it comes to tribal land and agricultural, the law changes when it comes to that. Yes, the law does allow them to acquire it, but you have to go through a process. You have to basically get consent. So consent can either come from two ways.
For both tribal land and agricultural land?
Yes. Consent can come from two ways, depending on the type of land that it is. The two laws that deal with it is the two acts that deal with it is the Tribal Land Act and what is called the Land Control Act. The Land Control Act specifically deals with agricultural land, and the tribal land, as we stated, deals with tribal area. So they set out exactly what needs to be followed, and usually if it's not followed, if it's done, because unfortunately this does happen, that foreigners just acquire land without going through this process of consent. As I said, you either have to ask consent to the land board or you have to ask consent to the minister of land. So that process requires there will be advertisement. There'll be a certain time period where everything needs to be done. And if it's not done, for instance, in the land control, if it's not done within 3 months, then already the transaction is called invalid. So you need to go through the proper process. And this is why it is very important. You cannot go through this process without using a lawyer. So, and I would also advise that you're better off to go through this process, as much as it may be a lengthier process and a bit more costly, but at least if consent is granted, then you will be a valid holder of, or you be lawfully entitled to buy that land. If you don't, what happens, and I've seen this, is that people have these agreements, you know. There are so many things that they can try and do. I'll just use this as an example. Sometimes you can put a foreigner in a company, or you can remove them. Let's say it's the foreigner's company. They'll be removed out of that company with a trusted local person. And I say this trusted because it's only to a certain extent really that you can trust people. So what happens is that this is just one example. It can happen in different ways. So I can say that, okay, I'll make them a shareholder, the 100% shareholder of that company, and then so it'll be as if they're the ones buying it. So now this won't raise flags at the land board or the deeds office, you know, because these are the things obviously they're also trained to look out for. Now you've purchased that, and then you say that, oh, after it's been transferred in your name, I become the shareholder again. So you see, now when those things are done, and I've dealt with cases, a very bad one where this happened. It was an issue with a farm. These ones were on the farm for 30 years. So you can imagine all the developments, everything that happened, and then it ended up being challenged. And what happened was that court will not enforce something that's illegal.
No, it won't. No.
So if a foreigner purchases land that way, whether they knew it or didn't know it, the law is the law. So if you purchase it like that, then or automatically it's invalid, it's illegal. So therefore, it doesn't matter if you say, I've been here for 30 years, I've done all these improvements. Obviously, you can try and claim something for improvements and what, but obviously, the pain of losing a place that you've been there for 30 years. So that's why it's very important when dealing with these sale of land issues to really go to a lawyer and get advice.
Yeah. Speaking as a non-lawyer, Mr. Pheto, what is the rationale for stopping non-citizens from acquiring agricultural land or tribal land? What is the reasoning, you think, the logic for it?
It's always good to, agricultural land is always good to be reserved for locals to perform whatever the agricultural activities in that land. We do want, we also as the country, we also want to have foreigners to farm, but we won't want all foreigners occupying or taking all the agricultural land. No, Botswana is now having any agricultural land. It doesn't look good. We also have to be part of the value chain in terms of agricultural produce and all that. As we know, the government now is encouraging the locals to start producing more. Food. You have to have our own food security. You have to now start to export our produces. So we won't allow or really entertain a situation whereby we just have an open law that even foreigners can just take agricultural land without any legal whatever the consent. So it's always it's a good system to have locals being the ones who really have to benefit from that agriculture.
Yeah, because the government is probably getting issues of food security, issues of political stability, and all that if foreigners just overrun the system.
Just to add on that, and just to add on what Gape said, is very correct. The initial stage of going through this process is that the property, it will be advertised, the sale. Yes. They have to say that and it's all details. You have to say that exactly the details of this seller is intending on selling this property to this buyer for and the details of the property and the amount of purchase price. And the whole purpose of this advert is to say that, are there any locals interested in this? So it does support what he has said. And at the end of the day, though, it is up to, as I said, whether it will be the minister or whether it will be the land board, yes, which will actually give consent. When one may ask that, is there an event that, okay, let's say a local is interested in that property and then the sale is cancelled? Yes, that is very possible. But then also the opposite is also possible. A local can be interested in that, but it is up to the discretion of the minister or the land board for whatever reasons.
Yeah, whether it's the land board in the case of tribal land, the minister in the case of agricultural land. Okay.
If they feel that there isn't an issue with the transaction itself, then they will give their consent, even if a local is interested in it. So it just depends on the circumstances.
Okay. There's a thing called value-added tax and the thing called transfer duty. When do those things come into play when we are dealing with immovable land? When does one have to pay those things?
Well, as I said, when you're dealing with a sale of land, it's a process. So before, and the last stage is actually the successful transfer of the land in the name of the buyer. Before that, it has to go to BERS. So bears will have to make sure that all the taxes are paid on the properties.
Botswana
before
Unified Revenue Service, for
Yes.
those who don't know what BERS is.
yeah. So they'll have to make sure that no transfer is going to take place unless you've paid the tax, basically. And both of them have to be paid.
Yes.
Either
Yes.
VAT or transfer duty.
Yes,
And what,
yes.
what applies when? When is it VAT? When is it transfer duty? Because I've always wondered about that. I think there are certain transactions when they say no, pay transfer duty. There are certain others where it says VAT. My guess is that VAT is when it's a company, and then which is registered
Yes,
for VAT, and then transfer duty is for the rest.
it's for individuals, yes.
Mm.
Yes.
Yeah, that's the way it is.
Is that the way it
Yeah.
is? Now, help me explain the cutoffs and the limitations for citizens, and so on, because you don't pay the same VAT. Citizens have up to, is it up to $1 million or 2 million?
Is it not 1.5?
I think they even increased it. I think
And-
in terms of
and-
transfer the first. Is it now $1 million?
Yeah, I'm not so sure.
I don't know if
of the
you
figure.
know about that. They was recently changed in terms
The
of
transfer duty, yes.
the transfer duty.
Citizens,
And,
it used to be 250,000 for citizens, but I think it's $1 million.
Yes.
In other words, if your property is worth less than $1 million,
Then you
there's
don't
no
pay.
transfer
have to
duty
pay.
payable. And anything above that, you pay. But there's also a different consideration for non-citizens, isn't it?
Yes, yes.
What are those percentages?
All right. The law actually recently had changed back. So initially
Changed back.
Well, it was 30%.
There was an
it was
outcry.
30%.
And this one, yeah.
30%
it was-
for-
30% now
Of the
It's now
price.
it affected,
15%.
it affected the economy now.
Yes.
Mm.
Because, now it reduced the forests now that are buying
Yes.
appetite. Now
Mm.
it's saying 30%. Then I would rather go and invest somewhere else. So the government, like she's saying, they had to reverse and say, now let's reduce so that we now.
Now,
have
what
the-
is it now?
The
the-
15%.
It's now 15%.
What was it before? The very
30%.
original.
It was. It wasn't 10 at one
It
point.
was around. I can't.
Somewhere there.
So it's closer to where it was
But it's
before.
closer
Yes.
to where it's
Yeah,
like. I
because-
think it was around 10%.
Yes.
before
Mm.
that.
At 30 it was killing everything in the economy in terms of the real estate market because our foreigners were suffering. Suffering a lot.
But also, when foreigners suffer, somehow locals suffer
Yes.
because there's no activity.
Yes, now I get the economy also now. Canada, some they come as investors.
Yes.
Yes.
Mm.
Imagine now.
And we
Creating
go all the way to
jobs
their
for
countries to
locals.
invite them to invest.
Yes.
It's just a chain of,
Mm.
of
Mm. And
transactions.
I think the amendment, right, the one that said our foreigners should pay 30%, it indirectly came back to bite the ordinary Motswana. In the sense that if, as a foreigner, I buy a piece of land worth 2 million pula, right, and I'm told to pay 30% transfer duty, that would be 600,000 that I would pay for the property. It then means that for me as a foreigner, if I'm now selling that property to a Motswana, I'm definitely going to demand that 600,000 that I paid as transfer duty. So it's going to be 2 million plus that 600,000. I want it.
Yeah.
So one way or the other, it would come back and bite the ordinary person or ordinary Motswana. Yes.
True. It's one of the one of the aspects that slightly raised even the prices of properties in the market.
Yeah.
And now they were not affordable as it used to be because they used to be
Like
affordable.
30%.
Yeah.
We know the inflation played part, but
Mm.
but it's even that as well.
Suppose I've entered into a deed of sale, but I want to resile from it. I want to pull out, to cancel. What are the steps that you go about cancelling or resiling from? Do you have to have special grounds? And so, what do you have to do? I think the lawyers will answer this one.
I think we should add on, of course. But once a deed of sale has been executed, once it has been signed, it's now a legally binding document, enforceable by the courts of law, and no single party can bring amendments, variation, and no single party can say, I'm now pulling out. Reason being, it's binding. The moment you put that signature, there is a Latin term called caveat subscriptor, right? Yes, which says once you have signed, it's binding. But of course, many a times there is a termination clause, and the termination clause is to the effect that if circumstances arise which make it impossible for transfer to take place, then one of the party can cancel. Or maybe if it so happens that the landlord declines to effect transfer, then the buyer can cancel and claim the money back. Or if it so happens that the buyer discovers that, oh my God, I was dealing with a fraudster, he can cancel. But besides such valid reasons and extenuating reasons, then a person cannot just wake up and willy-nilly say that agreement or deed of sale that I signed last week, I'm now cancelling it. Yes.
But aren't there special circumstances, for instance, if there's been default and
Yes.
and if there's impossibility of performance?
Yes, that's why I said
And so on.
except there are special circumstances. For example, transfer is no longer possible, or it has been seen that one of the parties is a fraud, failure to pay. Those are some of the circumstances that can lead to yes. But of course, you can add on.
I think you've explained it well. The main thing is that you're confined to the terms of an
Yes.
agreement. So irrespective of what you want to call this, a deed of sale or sale of immovable property agreement, at the end of the day, it's a contract.
Yes.
So there'll have to be, as you said, either a termination clause or you can also call it a cancellation clause. And there are different scenarios where it will be stated that you can cancel the contract. So, yes.
You mentioned an example earlier on where the seller is not actually the owner. So my question is, in a sale of immovable property, what happens when the seller is not the titled owner of the property being sold and a deposit has been paid?
Well, what can happen? Okay, first and foremost, the agreement is already unenforceable. So you can't enforce it in the sense of proceeding with the sale transaction. That's already, you can't do that because it's an illegal agreement at the end of the day. What you can do now, if you've already given, and this happens very often obviously, you've already given a deposit, you have to claim it back. And this is through, if the person is a bit honorable, you can just ask for it and hopefully they'll pay it back. But I mean, if they've already done fraudulent behavior, then I would advise that, you have to institute a case against them. If you want to try to do it yourself, I mean, you can actually institute a case on your own. You don't need lawyers, but it's always advisable.
I don't think a lawyer can say you don't need lawyers.
No, I'm just saying we have to be, you have to give the knowledge. Of course, I will still advise that it's better. There's a difference. I mean, as attorneys, we study, we have extensive knowledge and experience in this field. So you are better off than trying to institute a case by yourself. But I would be giving incorrect information if I can't say that you can go to court and try to institute a case yourself against the person who owes you, who you've given the money to. So that's the only way. You have to recover it. You can either use debt collectors, you can use a lawyer, or you can try your own efforts to recover that money.
Yeah, but
Okay.
to qualify what she has just said, you might have a right to claim, but and you might actually have the right to go to court, and an individual can go to court. But the question is, will you win? That's the question at the end of the day. Will you win? Because if you're going to the High Court is very technical. So if you miss one technical aspect, your whole matter might be dismissed with costs. So yes.
You need a lawyer.
We advise against that. We see it all
We
the
strongly
time.
advise against it.
And imagine there's a lawyer on the other side. I'll tell you, even if they're the wrong side, but lawyers know what to raise, like, as you said, technicalities. And I have seen this happen. I have done it myself and succeeded, and they've ended up paying costs, but my client was the one owing them. But because of technical things, you even file wrong papers, they'll file an application instead of summons. So it's not even that,
Yeah.
and lawyers know what that means. So it's not that you don't have a case, but it's very easy to make technical mistakes.
Indeed. Now, Mr. Pheto, the role of the land board now these days, can you clarify it when it comes to transfer of property, in terms of what they now do, and what are the formalities involved in transferring property via the land board?
After the introduction of the what do you call the
Secure land title.
secure land title.
In terms of the new act, yeah.
Yes, there's slightly a bit of a change in terms of now the processes of getting the land be in your names, because initially you'll have that certificate, what do you call land grant, travel land grant certificate, that you can't even get any monies from anyone with it, can be bonded. You have to change it from that to a common law, all those processes. But now, at least now, is after the introduction of that law, now what the land boards are doing is more like what was done by just private surveyors. They do everything in-house. They survey, they do survey diagrams, everything. It will be inclusive in that, that document. So as well as that, when now they used to have a law whereby if you want to have a transfer or you are buying from someone land, tribal land, they'll say you have to do the valuation. There is a valuation that now they need valuation.
The land board needs evaluation.
Yes, now they need valuation. It's not actually forced. They used to force it, but of late they also went back. There are a lot of laws that they just changed recently.
They don't enforce it that strictly.
Yes, now it's not that very strict like they used to, because they found that now just ordinary Botswana, I'm selling land to ordinary Botswana being good.
Like even giving it to your children.
Then you will need evaluation.
Costs money.
And care then. So the Botswana started saying, no, I can't just pay evaluation for just giving a plot to my son, or some Canada they can say no, I'm actually donating the land. So, but for now, at least the processes have just reduced. The only problem that we see at the land board is the time they take to now do transfer. I don't know the state. I mean the land title is now taking the whole time for the land board to assist people to transfer, because ever since that introduction of that land title, the process is just a nightmare. It can take months and months. I don't know what's wrong, but basically the role of the land board is just to administrate the transaction of the land, the tribal land, and make sure that all whatever it's zoned for, it's used for that. If it's agriculture, it's used for agriculture. If it's multi-residential, single res, should be. If you want to change, you also have to get a consent from the land board. And you have to advertise, like what she was saying, when a foreigner wants to buy, you have to advertise through Gazette, whatever
newspapers and so on.
Yes, to also get consent from whoever who have got objections. If there is no objection,
so has the new system with SLTs under the new act made it more cumbersome, more difficult, or has it made it easier to transfer tribal land?
It makes it difficult for them internally, but for like citizens, it's good, because it's just one document. You don't have to transfer it from that to that and have a surveyor survey. Just one document.
So why is it difficult internally?
I think they introduced the law prematurely before they themselves internally sort their systems. I think
in terms of what, computerization?
There was a weak link somewhere between the lawmakers and before checking. They did a law before checking the
I've heard Mr. Sisinyi cry about it in many. Sometimes in one of the earlier episodes of these nuggets, there's been an outcry about the way it's done. But let me ask the real conveyancer herself as to the actual steps and whether they are easy and if that if there are bottlenecks, how you go around those bottlenecks.
As I said, I think when you have a lawyer
Mm.
obviously assisting you with the process, then it's very easy for the individuals or the company. You really are not involved in much of the process.
Mm.
It is it's only that the difference is that at the land board you are the ones who are going to have to do the submissions and the following up. But really, in my opinion, I think that the process is more convenient. I think the law change is more welcome. I mean, just to say maybe on some aspects that he didn't mention, where, for example, you no longer have to develop property.
Mm-hmm.
You
Yes.
see, and
To
before
get it-
that,
to get
yes,
some-
to have
get a
it,
title deed.
To have it transferred.
to have it
To have it
transferred,
transferred.
exactly, and that is such a big advantage to people, individuals who are the owners of that property, because we all know the cost that it takes to even do that. What they have tried to say that, okay, since we're no longer requiring that of people, now there's a fee that you have to pay at the land board, which is 3,000 pula.
Mhm.
But I believe that it outweighs
Mm.
having to
Develop,
property.
yeah.
Because literally, and this was a very important clause in sale agreements.
Mm.
You see, you actually had to, especially if the property was not developed, you had to always put a development clause.
Mm.
And if that property was not developed, you can actually, then the agreement will now not be binding anymore, because you haven't complied. You have to develop, and even at the land board, they won't transfer the
Before
property
development.
before the developments. So I would say that there are some aspects that are really beneficial to whether it's sellers or buyers. I do agree, though. I would say that the land board does have challenges. It really does have challenges, and there's a lot of. I believe exactly the lawmakers should have, I think, seen the practicality of enforcing everything, but I wouldn't say that it shouldn't have been done. They should have aided, or they should have been a process of or it assigned to specific institutions or what to aid the land board in dealing with these matters. And it can even deal with the issues of where people are having fraudulent certificates, and there's even I have to say this, we all know this, there's also some corruption happening. We hear about this all the time, even through the government itself. So I do believe that they needed to create a separate institution to facilitate the land board.
But are things getting better or worse? On average, how long does it take to do a transfer with an SLT? How does it compare? I remember during the heyday of Lerumo Mogobe, where we used to tell banks that we can do transfers within 7 days, and it used to be our selling point. I don't think we can do that anymore.
No. Unfortunately, that's just the
We used to be
challenge.
able to do that.
I would say the deeds office is definitely faster. You can really have it done if there are no issues with the transfer itself. You can even have it done within a month.
So if it's non-tribal land, you go
Yes.
straight to
Tribal
deeds.
land.
It's actually easier. Tribal land,
is
that's the one that's
why
the problem.
there's a problem. There's a lot
Yes.
of problem after the introduction of this land titles.
Yes.
Now, everything
So on average, it takes how long?
Others-
Everything being equal,
It can even be 6 months plus.
6 months plus.
or for certain land boards, or generally?
Even it really just depends, because even the other ones, I said already, the Kweneng is usually where it takes the longest, but but I mean, you can submit it at other land boards and it can still take long, but it's just
Between
highly
4 to 6
unlikely.
months.
But yeah,
4 to 6
Okay.
months.
but it's definitely, you're not going to
Slow.
get it done less than 3 months.
Okay.
No.
Mr. Kuda, suppose, God forbid, the buyer fails to pay the full purchase price after transfer has been effected, for whatever reason. What remedies or what is available to the other party? The seller.
Okay, I think because transfer has already been done, cancelling the sale agreement or the deed of sale would not bear much fruit, because transfer has already taken place. Therefore, I believe the best port of call would be to sue. That is it, or maybe to make an
Sue for damages, or
yes,
for
to sue
the
for payment
the balance of the purchase price.
Suing for that could be one of the first, what you call it, first port of calls, making suing for damages, and then maybe also making an application stating any transaction to be done on that piece of land because there is an ongoing case. That would be the best.
Yeah.
Yes, I don't know.
To
Maybe
stop any
No,
development.
But isn't this a settled aspect of the law that where transfer has already taken place, the only option is to claim the money,
yes.
and therefore the transfer itself is irreversible without another application to court.
Yes.
Yeah.
So the question is, what would you advise the client to do? Do they try to bring a lengthy application? For instance, I'm thinking of even a situation where the seller doesn't have anything, or you try to attach, there's nothing to attach.
No, that's why I had said it might happen that the seller has nothing to attach. But then, like I said earlier on, it would be important that
I mean, is it the seller or the buyer?
the seller,
Who's suing?
The seller would be the one suing.
Yeah, suing the
So,
buyer. So it's the
yes.
buyer, yeah.
yes. So
When the buyer doesn't have anything.
So the best institute a claim for the outstanding balance, but also make an application to have a caveat put on that property so that no any other dealing can be done on that property, because as you're busy
To make sure they don't transfer.
yes that is it.
Well, okay. In addition, what you can also do is, since it's the buyer who hasn't paid the balance, but the property is already in their name, what you can do is definitely you have to do a case against them, claiming that outstanding money. Once you get judgment, you can attach that same piece of land and have it. So that's actually the easiest and what I would advise a client to do.
So in the meantime, get an interim order to prevent transfer.
Yes,
Yeah.
him transferring, the buyer transferring that land, and do a case where you can use that same piece of land to
Still
attach.
it.
Yes. And then you can recover it,
Yeah.
whatever portion is left.
So we're in the middle of the fourth industrial revolution, as you all know. So some of these agreements are signed electronically. To what extent is an electronic signature binding, and is it enforceable to where somebody has used an electronic signature? And is this already happening?
Well, yes. When it comes to, obviously, when parties sign an agreement, there will be an original one, but it is possible that maybe someone is abroad and you go the electronic way. The most important questions you should ask yourself is, at the land board or the deeds office, do they accept electronic signatures for
Do
sale
they?
agreements? And yes, they do. Actually, what we do as attorneys, we submit copies of the agreements. The only thing is that they have to be certified. It's a specific requirement that they have to be certified.
But not notarized.
Yes.
Who's going to certify without the original?
You know, it can be between you and your lawyer.
Yeah. There must
Especially
be ways.
knowing that it's a legitimate agreement.
So the lawyer will obviously have to check the original electronic copy, maybe
Yes.
on their screen, and verify.
Yes, you have to verify,
So
and even between the parties, that is this, you know.
So if someone is given power of attorney, can also sign on behalf of whoever.
Yes, supposing maybe to answer your question, supposing the seller is in the UK, right? So the seller can make a power of attorney which is notarized, and then maybe appointing their nephew, their niece, or their child, with power of attorney to sign all documents necessary to effect transfer.
Okay.
That is very possible.
Maybe this is a chance for you to explain briefly what notarized means, because some people may not know. I know that you are a notary public.
Yes, notarizing, you see, it's just like a notary public. That's what an attorney is called. That is a notary public. It's just
Which you are.
Which I am, yes. It's again, you have to go through the same process as being admitted as like a conveyancer. You have to go through the same process, have written the exam, or as I said, if you studied here in Botswana, then you've already done the exam, and you have to be admitted as a notary public. The whole purpose of it is about specifically authentication. So it depends also which country the documents are going to. So what is required is that they'll want, if it's documents from Botswana and they're going out to a different country, then it's the attorney, a notary public in Botswana, who will have to authenticate. And basically what you do, it depends on which country. Some countries require a certificate even, further than just the stamps, the seal themselves. It just depends on the country. But some, just putting a seal and a signature is fine. What it does, and the purpose of it, is to say that I confirm that this person was in my presence, and they signed, and I saw that it was them, and they signed that document before me.
Okay.
So it's really about authentication.
Okay.
Yes.
Suppose, God forbid, the seller now refuses to sign other transfer documents. What happens? And I know we've had 1 or 2 cases like that.
Well, supposing the seller refuses to sign some of the documents, we've made multiple applications to court, an application to compel transfer, that's what we call them. So with these applications, we seek an order that the seller be compelled to sign all documents necessary to effect transfer within a certain period of time, maybe 7 days or within 14 days. And
But let me interject to say, I've also seen deeds of sale with a clause that says this signature, by their signature on this deed of sale,
yes,
it constitutes a
Power.
power of attorney
yes,
to effect transfer.
yes.
Can you not finalize transfer based just on that clause?
Well,
Or we are talking about a situation where such a clause doesn't exist?
yes, when it doesn't exist,
Okay.
definitely, then you'd have to make an application to court, and then failing which, if the seller doesn't sign all documents necessary to effect transfer within the given time, then any other deputy sheriff of the court be given the power to sign all documents necessary. So supposing such an order has been granted by the court and the seller does not give heed to the court order, then a deputy sheriff of the court can be instructed by the attorney to say, according to this order and under the instruction of this court order, may you go and sign all documents necessary to transfer this property from this person to this person.
Okay.
Yes.
One final question, or last final 2 questions. Does the customary law have any role at all insofar as the law pertaining to property, especially immovable property and deeds of sale and so on?
Well, okay, there's a customary act in Botswana, and there is property that can be owned in terms of customary law, like such between chiefs, for example. So you would have to follow what that law, customary act states. I'm just trying to put it in a simpler way. Yes. So whatever the processes are, I would say this, like in my experience or in our firm, we deal more with the let's say
Civil.
more civil side,
Common
yes,
law side.
than customary side. But there is a process.
But to the
separate.
extent that you cannot transfer any property without a deed of sale, doesn't that really immediately take it out of customary law in a sense?
Well, I think to a certain extent it does, because I don't believe chiefs in Botswana have power to.
Transfer land.
Do they?
Well, if there's a dispute, they can make
No, to
rulings.
transfer land, to say
Yeah.
you have sold to this one.
can't.
They can't. That power is vested in the land board. Yes.
So
And
still
in
to
the
take
civil
it to
courts, I suppose.
Yes, in civil courts, of course.
Because I've come across situations where divisions of property are done at the khotla, but I've never seen it through as to how they are enforced. My guess would be that you still have to take specific action to enforce that order at the High Court.
You still have to go to the High Court.
That's what I believe.
Because the customary court doesn't have that power, actually. There are certain things it's actually limited in its power. And that land, alienation of land is one of them. So nonetheless, even though it could have some provisions, but it's specifically like alienation of land, you'd have to go to the High Court, not even
Yes.
the Magistrates Court, the High Court.
Okay.
Yes.
All right. As we conclude our conversation, and I think it's been a very robust discussion, very, very helpful. I would like each one of us to basically give a summary message and share with the viewers what their take is on this whole conversation, and then share their contact details as well as we wrap up. Starting with you, Mr. Kuda.
All right, thank you very much, Mr. Mogobe. My few words to the viewers are: do not get into dealings pertaining to land on your own. Have an expert on your side, have an expert in your corner, and that is an attorney of the law who will help you with due diligence, because if you do not, you stand a chance to suffer great losses. As such, do not hesitate to visit attorneys such as ourselves. We are found at Mogobe Plaza, the second floor in the CBD, and our contact line is 397-4002. I work with Mr. Mogobe and Ms. Nyirenda. Thank you.
And do you have any presence on social media?
Oh yes, you can find me on LinkedIn, and my name on LinkedIn is, as it appears on my birth certificate, Kudakwashe AV Chihita. That is it.
Okay.
Thank you so
Great
much. Sir.
stuff.
Yeah. Yes. I think to summarize it, I believe that there's been enlightenment over this area, and there's been various points where I'd say that they all lead to it is best for you to go to an attorney to assist with the sale of immovable property. I think there's no other better advice, because the risk is high. There's a lot that you can lose out of this, whether it's issues with your land or money that you may lose out of this. So I strongly encourage that. And don't do it on your own, because as we stated that there are many flaws when it comes to agreements that you've drafted by yourself, and some even excuse me, I believe that there's actually a common practice where people use agreements. I don't know where they get the templates from, but they
The internet.
Yes, internet. They use sale agreements. I would even say those are still not good enough. You should make sure that it is from a lawyer. Obviously, if it's from a lawyer, then there's no issue with it. But not just Google sale
Not
agreement
copy and paste.
Yes, no, I wouldn't advise for that. So I believe that there's really been a lot of enlightenment in this area of law, and better decisions would be made regarding it. My name is Thokozile Nyirenda. I'm at Lerumo Mogobe Legal Practitioners, and our contact is 397-4002. Our law firm's pages are on LinkedIn, we're on Facebook, as well as Instagram. I'm on all three of them in my own name, so you can find me there. Thank you.
Okay.
Okay, thank you. Okay, nanka garela ka gore okay, like the lawyer di se di buile we just learned gore the dangers of not following proper agreements tse di dirilweng ke di lawyer go no hela go tsentse mo diphatseng tse dintseng jang. So ne ke re ke kope mogedi ko gae gore jaaka sa utlwile bo mang ga ba buile le nna ke garela ka gore we all have to follow the right procedures. Re ska ra itirela tsone di deed of sale tseo. Let's engage our lawyers that are here to
Engage our estate agents.
Yes, we also have to engage estate agents to also help you in these transactions. Totala se salang ke gore sonzo go ha transaction yo hela both parties be di tumetse go se ka gonna di kgokgogano. So ka boksona ba ka nne kere a re direng dio ka ha molaong le rona hela re le rona as an individual re ithute go dira our due diligence by checking some other things hela ka bo rona, either go checka go ditsi, either go checka go land board wa letlelwa ka boksona bo ka nne kere nna ke bidwa gape Gordon Pheto. I'm an operations manager mo Mogobe Inc. Group of companies. Namo LinkedIn Kibidwa Gape Pheto. My number is 7138-1980-7485-4746. Thank you, Mr. Mogobe.
All right. Thank you very much. I would like to thank my panel in a very special way. my team. This is a very useful team to have, and I really appreciate their input. Especially, I'm very, very delighted by what they had to share. I believe they have empowered you. They've lived up to our ethos here, which is to enthuse, energize, inspire, and to empower. And please strike that subscribe button. And again, if you're interested in learning more about us, the book is available. You come to Mogobe Plaza, and it's also available from Exclusive Books. But once again, adios. Bye-bye.